The Honourable Chris Fidlerson.
I'll address that point raised by Dr Graham in a minute, but first I want to address questions that have been raised a number of times today about who would be caught by the definition of terrorist act and thereby become liable to having their passports cancelled. A number of hypothetical instances have been raised, and I tried to deal with them in the second reading speech, but I'll just try and go through section 8A and the proposed new schedule fairly carefully for the benefit of members again. The first point that I think needs to be noted, sir, is that each and every case is different and turns on its own facts, so I can't give absolute blanket assurances in the House about whether someone will or will not be caught. The second point to note is that the test to be satisfied before a passport can be cancelled has a very high threshold. There has to be sufficient information available to satisfy the Minister of Internal Affairs on reasonable grounds and the following conjunctive tests. First, that the person is a danger to the security of New Zealand or any other country because they intend to engage in or to facilitate a terrorist act, and the danger cannot be effectively averted by other means, and the cancellation of the passport will prevent or effectively impede the ability of the person to carry out the intended action. So all three limbs of the test must be satisfied before a passport can be cancelled. The third point is that the legislation doesn't prevent New Zealanders from travelling to these areas, although we would strongly advise against it. And that's the point I guess I was trying to make in the Herald article that Mr Goff was referring to. Not saying you can't, but saying it's not the cleverest thing that you could possibly do with your life, assuming you'll be able to hold on to your life if you go there. The only people who'll be caught are those who intend to carry out or facilitate the terrorist act. And again, and it must be emphasised when one looks at the ingredients of the clause, sufficient information would be required to satisfy the Minister on reasonable grounds that the elements of that definition have been met. So clearly, take this hypothetical, someone wants to, from the Assyrian Christian community in Wellington, wants to go to Mosul to see their family, to provide whatever support they can in a horrific situation. One could advise them against going, but clearly there's no grounds to stop them going. Humanitarian workers and those who go to help their families in a dangerous environment will obviously not meet the test. If they join a group engaged in conflict, they'll not be caught simply because of that fact. They may, in fact, one could classify them in moral terms as freedom fighters. They must intend to commit or facilitate a terrorist act before their passport can be cancelled. Now, the power is used sparingly, and my advice is that only 9 passports have been cancelled under Section 8A since 2010. And then the other point that I made in my second reading speech is and in the introduction to the committee stages this afternoon is that the exercise of this power is subject to appeal to the High Court and with leave to the Court of Appeal, and the Court can substitute its own discretion for that of the Minister to confirm, to modify, to quash the decision. So it's a real check and balance on the Minister's decision making. Now, Mr Goff and Dr Graham raised some interesting points about the definition of terrorist act, and I hear what they're saying. And we're not dealing with Section 5 as such in the debate tonight because it's already in the Terrorism Suppression Act, but I for one, think that the definition of terrorist act is a challenging one. It's been drafted to meet our international obligations, and some amendments were made to it, I think in 2007, to make our laws more consistent with our international obligations. It's used in a number of statutes, not just for passport cancellation. careful consideration will need to be given to any amendments to make sure we continue to meet our international obligations, Mr Chair.
The Honourable Christopher Finlayson.
But I'm perfectly happy to raise that with other ministers, because I think it's something that could be included in a wider review of the criminal law applying to this area, and in that context I refer honourable members to Part 5 of the Crimes Act. I've talked about looking at the crimes against public order. Treason is there. Seditious offences was once there, as Mr Mark knows, but it was repealed in 2007, and you've got slave dealing, piracy and so on. And it's fair to say, I think, that Part 5 is overdue for consideration. So part of the review of what we're doing will involve looking at Part 5, and in that context one could actually take a good look at the definition of terrorism, but not simply the point I want to emphasise is that we have to be consistent with our international obligations, and that definition is used in a number of statutes. So very happy to look at that, because it's probably timely to do so. The other point I'd make about reviews, and this comes from Section 21, I think it is, of the Intelligence and Security Committee Amendment Act 2013. What we are going to be doing next year, and it has to be commenced before 30 June 2015, is a review of the intelligence and security agencies, the legislation governing them, and their oversight legislation. So some of the points that Mr Goff made about the Inspector General, and I think they were very cogent points, all that is up for review in the period of 2015, and what I hope will happen is that the reviewers and both the Intelligence and Security Committee will be consulted, and I'll make a point of independently consulting Mr Goff and Mr Shearer on the reviewers and the term of and the terms of reference of the review and so on. The reviewers will be able to look at this area in 2015, and then there will be ample time in 2016 for a full select committee and then a principal debate on whatever emerges, with a view to concluding that before the expiry, the sunset period hooks in, which will be, as this has been confirmed in the legislation tonight, 31 March 2017. So I think that there is ample opportunity to have a good look at all these matters, both the sedition question that was raised by Mr Peter. Well, good luck to him in his quixotic quest to exhume sedition, but certainly in terms of Part 5 of the Act, the public order offences and the definition of terrorist act, all that can be looked at as a separate piece of work.